but now have quorum actually.
And now, and it just started, so.
And now we started. I'll restart. All right, so here we are for the Remedies Subcommittee. Thanks everybody for being here today and making this fit. I know this is an extra meeting for us. Just to note, with my presence, Josh Esme and Jean Evans, we do have quorum. So I would note that a copy of the October 31st meeting minutes are posted to the task force website. If there's any corrections, additions, anything of that nature, please speak up. Hearing nothing, I will note that they are approved. So just to kind of update, I guess, all of you from our last meeting, I did speak with Tiffany Kaser, and actually she and I got off the phone shortly before this meeting, and I think she and I reached some consensus. So first of all, and I'm pulling up just because I was working off of these slides that had previously been prevented. One, she did not voice any concern that family assessments would not be used to calculate whether maltreatment is reoccurring. She and I did talk through that process and how family assessments are not appealable. And so once we went through that together, she did not have an objection to that. She also, I clarified for her then that our recommendation that a hearing is available, that really we're talking about that entire disqualification appeal process. So an individual who's being disqualified based on a serious or reoccurring maltreatment, regardless of the outcome of the maltreatment, can request a reconsideration for both correctness and risk of harm, which would then ultimately get the person still to that hearing process. And so I think once I clarified that, and assuming that's really what we were talking about, because I know our presentation talked about a hearing, and the point is how to get someone to that hearing process. And so once I clarified that, she was fine with that. And then the only other piece was she did say it might be difficult. She voiced some concern about the clear and convincing standard, but more about whether that could actually really get passed, not so much that she had a strong objection to it, just because it's a different standard. So that's all.
So whether the legislature would pass it, that's what the politics of it, not the policy merits. Okay.
Yeah. Yep. So once she and I went through that, I think her just request was that, that when we do draft that recommendation, if we can just keep it clear, obviously I think when she heard hearing, she wasn't sure if that was a whole separate process that we were trying to recommend. And I think that that's where that confusing for her, or whether this is a process within the maltreatment itself. And so once I clarified, it's still within the DQ process, what we're allowing to have happen, that made sense. And she just wanted to make sure the language, when we do recommend it, is clear on that. Make sense?
Okay, so in the end, she didn't have much concerns about impacting like unintended consequences for other policy areas?
Mm-mm.
Okay.
Nope. As long as we're sticking to within the disqualification process. So I think we're good there. So I need to pull up. I'm sorry, I have too many things open on my screen right now. I was going to pull up the recommendations we were working on last time, and I just don't remember where I saved them.
While you're doing that, can I just flag one issue that I noticed while presenting our summary recommendations 2 meetings ago for the full group? Will had put together the slide, and I went through it. And while going through it, I didn't see on there a recommendation that I know we had talked about at least early on, but now I don't remember if we had finalized when we actually like dug into the process stuff. which was that with respect to any permanent disqualifications that would still remain after the revisions, that save for ones that are mandated to comply with federal law, Adam Walsh stuff, any of those, the permanent disqualification list that isn't Adam Walsh related would still be a permanent disqualification length, but would have the bar to the set aside removed. Right? Am I remembering right that we had thought that like you should at least get a chance to petition for a set aside?
I know we definitely talked about it, and I think you're right. I don't know that we.
And I did.
I mean, I know we had lots of conversations.
I put it on the record at the big meeting. So I don't think we would be like stealthing it in, having not talked about it at the big meeting if we included it now, but I do think that that's an important one.
Okay.
Yeah, I have another one too that we forgot about.
Okay.
Are we done with that? I don't want to, if we want to finish like getting that on the record or whatever. Kelly, Representative Moeller had mentioned us talking about blind reviews of applications, getting rid of people's names, gender, birth date, addresses, as DHS is reviewing applications for set-asides to get rid of implicit bias. And I think that is a really good idea.
That is a good idea.
And
Agreed.
so, yep. So, like not being able to see people's names or like what neighborhoods they're from or whatever. And I think even whether they're male or female is,
Mm-hmm.
and like, yeah. And where in the process does it, like, is it at the set aside process or is it even at the application process, right? Or that doesn't matter?
I don't think there's no discretion at the application process.
Okay.
Yeah, I think it would have to be at the
Set
set
aside
aside.
process. And so where would we put that in?
I think both of the one that I forgot and that one are both good. Just to go in
Remedies.
the process section.
Okay.
I apologize. I cannot find, I know we worked on editing it last time and I cannot find the edited version. Will, what you sent me is not the edited version.
Oh, okay.
I don't know if I accidentally didn't save it right.
Just a moment, Madam Chair.
Were you working on a Word document?
Last time around when we were working on, and I was making edits, as you weren't here yet,
Mm-hmm.
but I was making edits to our bullet points one. And I don't know if I didn't save it right, which would be unfortunate.
Yeah, it looks like you just sent me the older version, Madam Chair. Apologies for not catching that.
No, shoot, sorry guys.
And just so you guys know, who I've gotten these out to so far, just like the preliminary, is MACAC, which is probation, MAXA, which is social service, and March, which is substance use disorder. If you guys have other thoughts about who else we maybe want to get this out to, my plan is to get it to Bill Hutton. I mean, they're kind of represented here through Andy office. I mean, there's a chief of police or whatever is represented on board, but
Well, I know there was a lieutenant for a while, but I don't know if he's.
yeah, he came the last time, I think. Andy, somebody.
Lieutenant Knox, Ms. Adams.
Yeah.
Are you just like trying to circulate them to orgs that would be interested?
Yeah, and if you guys want to do that as well, Will was nice enough to work on a document that has the recommendations.
Are we looking for feedback?
Yeah, I just don't want to get blindsided, with a bunch of people that have stuff to say about it. Like,
So are you like giving it to them with like an invitation for a public comment?
no, I
Or
mean,
just give me your feedback?
yeah, just like, here's what we're thinking, does anybody have thoughts? No promise to make any changes, just like.
Maybe MACDL?
Do you want to send it over there? Or you
Sure,
want me to? I don't really have a contact over there.
I can.
And it could go out after we get to the end of, like, right now it's just preliminary, and after next week we could send it to, but that was the other thing we could do, is like, we're running out of time though for like public comment,
Second Chance Coalition?
Yeah, yep.
I think all of those make sense. All right, so
Madam Chair, I actually pulled up a recording of the previous meeting, which we should be able to see the document on screen if we just want to read off the language that you had inserted. I don't know if that's too cumbersome though.
it might be pretty cumbersome. I wonder if it makes sense. I wonder if it makes sense, because we were only in the permanency subcategory or division. If let's talk about let's work on preponderance of the evidence and see how far we get, see if we can get through that and into process. I have a hard stop at 5. I got to get kids to activities. So I want to make sure we start working on this draft and then figure out how to try to recover what we did on permanency, rather than, maybe I can do that after rather than try to take time right now.
What exactly are we doing? Are we turning bullet points into like more fleshed out?
Yeah. That's the goal, is to try to flesh this out a little bit more in a more written format that will then ultimately go to whoever is the writer to then bring it all together in a cohesive manner. But I think our subcommittee is strong enough that I guess my thought is that we can probably work together, and we have enough writing and knowledge about all of this for us to write as much as we can. And then that leaves less for whoever the actual writer is. Does that make sense?
Mhm.
All right, I'm going to share my screen. And then I promise I will save what we work on. All right, so this was the bullet points that were drafted that everybody was working from. And I think kind of what we talked about last time was, when you look at these types of formats, I don't think we need to do as, formal as a normal legal memo, but essentially we're looking for each topic, sort of doing an introduction, what the problem is, what the recommendations are to fix it. And then I think what we ultimately decided is, let's get that all written out for each of these different buckets. And then we can go through and highlight what we think actually needs to be changed in the statute for wording. Because I think my concern would just be, otherwise we're putting the cart before the horse. Is that still what we think?
Yeah, I'm not sure. Does our report require us to give proposed statutory changes? I thought it was like policy changes, and then we'd work with the legislative staff to get bill language.
That's what it says. I don't know that we're gonna have time though before the 15th.
Oh, it does say it wants proposed language.
It does.
Okay.
All right, so just kind of getting started. So if we're gonna like I said, let's just pause on the permanency. I will have to try to figure out if I can sort of recreate at least where we were at. Let's not start over. Let's see if I can recover some of it first. So then preponderance of the evidence is, you know, I know this one, I think if we even want to start with, as we talked about last time, sort of an introduction as to how we got here and what the problem is. So I know we talked about this one a while ago. But I guess to me, it was always, you know, we're using a standard that where somebody's never actually been convicted, where guilt has never been proven, and now their job essentially hangs on the line. And I think, you know, it is right now under the current scheme, as we learned, they are not using, unless there's been a charge, they haven't been using the preponderance of the evidence for anything other than that, but that policy can always change.
Yeah, it has not always been the case.
Right.
Yeah, I mean, I would say the nutshell problem is it creates a high likelihood that innocent people are going to be disqualified from working based on things they didn't do.
Based on crimes. Well, and I think kind of like what we talked about, even more than that is, you know, because right now, for example, even if you get a continuance without a plea, you're still being brought in under the preponderance of the evidence. So even if somebody has been charged and they get the benefit of the system that is designed to not have it follow them, it's still following them.
Mhm.
Yeah, so it disempowers the criminal legal system from reaching fair resolutions that protect people's ability to work, but also safeguard the community.
Individual.
And I would argue that the actors in the criminal legal system are in a better position to make those determinations. They know the people involved in the case, they know the facts better, they know the strengths and weaknesses.
You phrased that really well. The current framework takes away from the power.
Yeah, to reach a fair outcome that, you know, that balances for example, someone's ability to work with protecting the community. And I guess sort of the reason I think that's important is that, like, the prosecutors, defense attorneys, and judges have a lot more information oftentimes than DHS has when they make these preponderance of the evidence determinations and they're just looking at police reports, right? You're not going to get the defense's investigation notes, you know, for example. You probably won't get statements that witnesses give to prosecutors that oftentimes involve recanting or changing the facts and minimizing, mitigating circumstances, all those things.
Okay.
You know, that might be too much.
And then I think actually what's funny is this first sentence pretty much sums up I'm actually gonna do.
Oh yeah, we already had that there. At least we're
Actually, what I'm gonna-
consistent.
I know. I think what I'm going to do is I'm going to take out these first two sentences because I think how we phrased it there is. Okay, wait. Actually, I'm just going to do it to the first one. The first sentence, I think we just I like how we worded it. So then, I said, so then I think what I'm going to say is the subcommittee explored other states, and federal guidelines, which seem to rely more heavily on convictions rather than the POE standard. Based on our research, Minnesota is unique in that it appears to be, are we the only state? Did we ever find another state?
I don't think we did.
Okay. I just wanted to make sure. Okay, so then I want to to me, it makes sense to literally do like a all caps recommendation so that it's clear. Disqualifications will no longer be made on a preponderance of the evidence standard. Disqualifications will only be made for convictions and stays of adjudication. And then I'm wondering, okay, so then are we good with that? I mean, to me, this recommendation is our shortest and simplest and most straightforward. I don't know that we need to be very verbose.
Yeah, the only thing, I guess another thing that we talked about as like a justification is that litigating these preponderance of the evidence determinations has got to be one of like the things that creates a lot of work for DHS. So this like will also streamline the process and make it easier.
Okay.
And cut down on the overburdened agency.
Okay. And maybe that goes here. So currently disqualifications based on a preponderance of the evidence can be litigated through the fair hearing process by the disqualified individual. The recommendation below will streamline the process and reduce the current workload for the Department of Human Services.
Yeah, and the AG, I guess. I think it's the AG that usually reps them at those hearings. But before they even get to those hearings, DHS has to do a bunch of work on it. So
right. I think that makes sense. And then, so then for does it make sense to everybody if I do, so we've got the preponderance of the evidence, and I get why we have maltreatment under here too, but I think I'm gonna almost do that as like this whole now next category. I mean, like within here, and then we'd have a second recommendation paragraph. Does that make sense?
Yeah, that's fine.
Okay. So under the current, I don't know if I need to write all of this, but whatever. Framework, disqualifications are based on serious or recurring maltreatment. Maltreatment findings are the only disqualifying event which are proven by a preponderance of the evidence. The other enumerated crimes have to be proven by have to be proven by either clear and convincing evidence, because TPRs do. Clear and convincing evidence or proof beyond a reasonable doubt.
do you want to say current recommended framework? Right, because this is true if they adopt our previous recommendation, right?
Oh, yes, under the current, that makes sense. Crimes slash events have to be proven by either the current disqualifications for serious or reoccurring child maltreatment, so child or vulnerable adult. Adult maltreatment can or are made using family assessments, which are not appealable. Lastly, and I'm happy to say, I guess, to me, I know we're not here to discuss the maltreatment process, but to me, one of my concerns and why I would want to make sure that this is a clear recommendation is that, a maltreatment is a process where someone does not have an attorney. It is not always clear. And I'm trying to think, the maltreatment process itself uses a different set of statutes. Individuals are not entitled to counsel and can be confusing and cumbersome.
Lucas, can you zoom in a little bit just to make it bigger on our? I'm looking on my
Here,
little-
what if I just make it? What if I make the print bigger? That should work, shouldn't it? Let's change it to 14. Does that help?
Yeah.
So what I have under the current recommended framework, disqualifications are based on serious or recurring maltreatment. Maltreatment findings are the only disqualifying event which are proven by a preponderance of the evidence. The other enumerated crimes / events have to be proven by either clear and convincing evidence or proof beyond a reasonable doubt. Disqualifications for serious or recurring child or vulnerable adult maltreatment are made using family assessments, which are not appealable. Lastly, the maltreatment process itself uses a different set of statutes. Individuals are not entitled to counsel, and it can be, the appeal process can be confusing and cumbersome. Trying to think of any other problems that we identified as to why we're making our recommendations.
I think we might need to explain a little bit more about family assessments.
Okay.
I mean, it's not just that they're not appealable, it's also that they're like really perfunctory.
Right.
They're done for a different purpose other than identifying wrongdoing.
Family assessment.
Other than gathering evidence of wrongdoing.
Right. The purpose of family assessments are also to offer the family services rather than making a determination of wrongdoing.
Yeah.
Does that make sense?
Yeah. Or I mean, the reason that's a problem, right, is that they're like a poor substitute for an actual investigation, right?
Right. I mean, they still technically complete an investigation, but I don't think I would say it is as, it's typically not what I would say as thorough. And just there aren't even the same rights. So what are they for? So the purpose of the family assessment is kind of that precursor of, there's some issues here, but can we offer services to help this family? Therapy, this is a family need,
Could we
bus-
say that? Because I think sometimes people are more like open to what something is instead of what it isn't. And so a family assessment is intended for this and not gathering evidence as is intended for court proceedings, right?
services
I like
such
that.
as therapy, or parenting education.
Can we say, instead of intended to offer the family assessment is it intended to determine whether the family would benefit from services?
Okay. So the purpose of family assessments are to determine whether the family would benefit from services such as therapy, parenting, education, etc. I'll just say etc. Rather than making a determination of wrongdoing.
Yeah.
Or maybe I just say maltreatment,
Mhm.
because that's technically what it's for. Um,
And so, and because of that, they're not as
Yep.
thorough.
And therefore should not be the threshold used.
Family assessments should not be the threshold used when determining whether maltreatment is recurring.
Good job, team.
All right, so
But, hey,
then,
can I suggest whether to disqualify someone
sure,
due to recurring maltreatment?
yep. So to disqualify someone for recurring maltreatment.
One more suggestion on that paragraph.
Yeah,
I don't know why I'm so OCD
okay.
about this, but the very first sentence, I think we should just say under the recommended framework, just drop current.
Okay. It's okay. So caps lock recommendation. Okay, so, and this is where we just have to be clear, based on my conversation with Ms. Kaser. So disqualifications. So disqualification, I think it should be disqualification determinations. I think we need to be clear on that. Based on serious or recurring maltreatment will be made using a clear and convincing standard rather than the current preponderance of the evidence standard under the disqualification statute. I want to be really clear. Just, I guess to me, I just want to be clear on that.
Do we want to just say disqualification determinations under 245, under chapter 245C?
Sure. That makes sense. That's shorter.
And then cut it from the end of the sentence.
Yep. Family assessments will not be used to calculate whether maltreatment is reoccurring. An individual that receives a disqualification may utilize the request for reconsideration process and fair hearing process to challenge, and obviously I'm just trying to get something on paper and then we can fix it, to challenge the disqualification for both correctness and risk of harm. Is that, and that is what we're like, does that make sense?
Individual that receives.
Oops, I should say me.
And it's request for reconsideration, not requestion for reconsideration.
Yeah, thank you.
I don't even know what a requestion means.
I don't even know why that wasn't underlined. I need to look that up after this.
So an individual that receives disqualification. Yep. Are we trying, that might be read to say I wonder if that read in connection with the previous sentence makes it sound like there's a clear and convincing standard for the risk of harm part.
Oh, so, okay, so should it say disqualification? Well, I guess that's a question. Are we saying it's clear and convincing evidence for only the correctness?
Well, when you say risk of harm there, you're just, are you meaning the set aside?
Yeah.
Well, I guess thinking that through, I'm not sure, isn't that already how it is? Is that a recommended change?
Well, I think our goal, the correctness piece was the concern. They'll always get the ability to apply for the set aside based on risk of harm.
And they currently can't use
Well, and I think
request for reconsideration process to challenge the correctness of the maltreatment determination? I thought they could.
I guess, well, I guess, is this, let me ask it. I guess my thought process was they couldn't, but I don't know why. I guess let me just ask this, because we said hearings are always available for disqualification. So what we're saying is they still have to go through the request for reconsideration process. We probably have to go back and look at that one of those very first handouts that we got.
Does the county ever make a serious and recurring maltreatment determination not related to a DHS background study?
Yes, I've seen it.
So maybe that's what we were thinking of, is that like you can't, if that's already done, you don't get to challenge it again at the DHS level. Is that how it currently works? Maybe, and that's why we were thinking we needed to make sure that we protected your ability to challenge it at the DHS level.
I think, well, maybe what I'll do is just highlight this. And we'll have to go back and look at one of those original handouts that we got, I know, talked about the process and how, sort of that flow chart of how you get where.
Okay.
But
I think we're right that our idea was that nothing that happens at the county level shuts you out of challenging challenging the correctness of a maltreatment determination for the purposes of whether you can work.
Right.
And maybe that's why Tiffany was, or Ms. Kaser was like sort of confused about why there would be weird interactions is that we're kind of like separating out the two systems in order to preserve someone's ability to access work.
Mhm.
But I think in theory, then, if that's how it would play out, it would mean you could have a serious and recurring maltreatment determination at county that takes some action vis-a-vis, for the children or the vulnerable person or whatever. You could then challenge it in this separate venue and win and get access to work in this separate venue without upsetting anything that's happening at the county.
Mhm.
Right? It's almost like winning on a DUI when you didn't challenge the implied consent revocation. You have one consequence, but not the other consequence, and
Right.
two different systems giving you different answers about whether wrongdoing occurred.
Yeah, well, and I think the other piece, so like one of the examples I gave her would be reoccurring, like say somebody gets a maltreatment finding for neglect, and at that point in time, it doesn't affect them, but the reoccurring, there might be a variety of reasons, or I don't have the money right now to appeal, so it is what it is. Doesn't matter right now. But then there's a secondary, well, now you've got the reoccurring, and then even if it would force people to challenge all of them all the time versus
Right.
once it actually matters.
Right. This would let you accept a small consequence from the county that it makes more sense for you to just accept that consequence than litigate the heck out of it. But then 3 years later, when your job is on the line, come back and litigate it.
Mhm.
Yeah. Okay. So yeah, let's go back and double check that we've got the path through the system correct. But
Yeah.
I think on the policy level that makes sense.
And then
I wonder if you can just cut out risk of harm from that sentence that started us down this path, because you could already use that policy, that process to challenge risk of harm, and we're not changing that in the recommendation.
True. Mm. And I think, well, then does it make sense to say the individual, regardless, I just want to make sure the legislature, it's hard if you don't put it in there explicitly, could you end up losing it?
Sure.
Regardless, can still challenge the disqualification or a risk of harm as currently outlined.
Cool.
Okay, so then I think with this whole last part, we don't need. This part that I have in gray.
Maybe keep the even if the individual did not appeal the maltreatment at the local level,
Okay.
you could put that in the last sentence in the highlighted period.
Okay.
Actually, right at the end of correctness, I think.
Mm-hmm. So that would be this that would be removed.
Yeah.
I just think we already have up top the clear and convincing, and then can still appeal even if it was not done. I think.
Yeah.
All right. If you're okay with it, I'm going to hit delete.
Delete.
Okay. Okay, I think that finishes our written recommendations for preponderance of the evidence. Yay. All right, so then moving on to process. I think we already got some of this right here. One of the problems with the current process is that it does not give the reviewing agency enough discretion. I think all of these are process needs to be more user-friendly. So to me, these other problems were reviewing interview, oral appeal process takes too long. I think a lot of these, I don't know, do we need these bullet points?
I mean, some of them need to be fleshed out.
Right.
If you guys want, I would volunteer to just go through and clean this up, since most of these are my short bullet points already. And I could try to bring that to our next meeting instead of trying to write all of this as a group.
Sure.
We got like 10 minutes, right?
Right.
Um,
I
I
think
think now that we have a framework, right, to do it in.
Mhm.
And then the beauty is after each one of the things, we can dump in a piece of data, right? Here's some data that supports it. Like we did that, but like put in a graph or a chart or something underneath it.
Yeah. I think that makes sense. Well, here, I'll stop sharing and I'm going to save this document.
when are we meeting again?
Tuesday,
We have a meeting scheduled for next Thursday, Madam Chair, Ms. Evans.
Thursday.
Yeah. At the same time, 4 o'clock.
So if Lucas, you
Excuse
can
me.
try to go back and capture from the video the
Yeah.
stuff we did before, and I'll take the first crack on that, and then hopefully we can just use Thursday to like finalize it.
I think that'll be good. I will, I'll email this to you. And then
And I'll make sure it's the updated version, Madam Chair.
I did a save as so that it's different. I didn't try to save over. So I will get this over and then we'll go from there. And if everybody's fine, I think it makes sense to adjourn and work on our various pieces, and then we meet next week.
My brain is also fried.
Well, there's that too.
Been a long day.
There's that too. So, all right, that sounds good. Well, thanks everybody for making today work, and we're almost done. Home stretch.
Kind of.
All right, have a good
Will
night.
you send a copy of that, what we're working on right now? Will you send
Yep.
a copy of that to me as well?
I'll forward a copy of that to the whole membership, Ms. Evans.
Thank you.
All right.